Welcome everyone to this Wiser Center for Europe and Eurasia roundtable. Is Polexit on the horizon, Poland's domestic policies, law, and the EU? My name is Geneviève Zubrzycki. I'm professor of sociology and director of the Wiser Center for Europe and Eurasia and of the Copernicus Center for Polish Studies. Today's event is co-sponsored by the Copernicus Center for Polish Studies, the Center for Russian, East European and Eurasian Studies, the Center for European Studies, the Center for Political Studies, and the University of Michigan's Law School. Poland is in the news every day these days. The BBC is reporting daily on the situation on the Polish-Belarus border. Same thing in French media, the New York Times, the Washington Post. And earlier this fall, because of tensions with the European Union, and more recently, because of the refugee crisis on the Polish-Belarus border. So in the last 2 months, basically, we've heard a lot about what's going on in Poland, and the political and humanitarian crisis has also become a EU issue, as Poland's eastern border is also the EU's border. And it will be interesting to hear our speakers today comment on how the border situation is impacting or perhaps even repairing a bit strained Polish-EU relations. So we wanted to have a round table of speakers explaining to us what's going on between Poland and the EU, how the current crisis on the Belarus-Polish border is playing out in that conflict or tensions. But before introducing our speakers and ceding the floor to them, I'd like to provide a bit of background that will be helpful for our discussion. So Poland became a member of the EU on May 1st, 2004, and it was a major achievement for Poland. EU accession, in effect, marked the closing of the long decade of transition that began with the fall of communism in 1989. And tensions with the EU started to be visible mostly in 2015. There was a significant conflict over the Polish Constitutional Court and judges of that court, and our speakers will address that. But other issues concern logging in the Białowieża forest and Poland's refusal to accept refugees under EU's relocation program in 2017 during the Syrian war. The most recent issue concerns Poland's Constitutional Tribunal ruling a month ago that key articles in the Treaty on the European Union are incompatible with the Polish constitution. The ruling set off a confrontation between Poland and the EU, large protests in Poland, and general fears both in Poland and Brussels that Poland is moving toward a Polexit. Is it? Well, there were always Eurosceptics in Poland and in all EU member states for that matter. Support for joining the EU and remaining in the EU is quite strong in Poland. According to a poll conducted by the Center for Public Opinion, CCPS, in 2014, for example, Poland's presence in the EU was supported by 89% of Polish citizens. In the late October poll conducted by that same research institute, CCPS, over half of the Polish population, so 52%, did not think that EU membership impinged on Poland's sovereignty, which is the argument that the current government is making, as opposed to 34% who felt that it does. And these opinions follow political cleavages. 66% of supporters of Law and Justice, the party in power, and 60% of another right-wing party, Konfederacja, find that EU membership threatens Polish sovereignty, as opposed to 93% of supporters of Citizens Coalition and 79% of the left who do not agree with that assessment. So we see that interpretation of EU and whether or not the EU impinges upon Polish sovereignty is really reflective of political cleavages in Poland. So in this roundtable, political analysts and experts in EU and Polish law will discuss the current crisis' political origins, its institutional underpinnings, and its potential outcomes. And I will introduce now our speakers in the order in which they will appear. Jarosław Szczepański, is Assistant Professor of Political Science and International Relations at the University of Warsaw and at the Academy of Justice at the Institute of Law in Warsaw as well. This year, he's a Fulbright Fellow at Ohio State University, and his main research interest lies in the field of philosophy and theory of law and politics. Our second speaker will be Marcin Menkes, who's Associate Professor of the Warsaw School of Economics and Visiting Professor of Law at the University of Michigan. His professional interests include international business, law and governance, and state immunities. Menkes is presently involved in research projects on international investment, law, and the rule of law. Our last speaker today will be Sławomir Sierakowski, sociologist, political analyst, and co-founder of Krytyka Polityczna, Political Critique, a Poland-based but Eastern European-wide movement of liberal intellectuals, artists, and activists. A graduate of the University of Warsaw, Sierakowski has been awarded fellowships from Yale, Princeton, Harvard, the German Marshall Fund, twice from the Institute of Human Sciences in Vienna, and the Bosch Academy in Berlin. He was a director of the Institute for Advanced Studies in Warsaw and is a senior fellow at the German Council for Foreign Relations. Sierakowski became a contributing author for the New York Times in 2013, and he's a monthly columnist for the Project Syndicate since 2015. He's also a weekly columnist for Poland's largest portal, onet.pl, and a political commentator for the weekly news magazine Polityczna. He's contributed essays and op-eds focusing mainly on Polish and European politics and culture to publications including the Financial Times, Foreign Policy, The Guardian, Le Monde, Der Standard, Le Nouvel Observateur, El País, and Haaretz, among others. So each speaker will have about 15 minutes to discuss a specific issue or aspect of the current crisis. And then we'll have a discussion, including your questions to specific speakers or to all of them. And I invite you to write your questions and pose them in the Q&A button at the bottom of your screen. And when it's time to open to the floor, I will collect the questions and pose them to our speakers during the discussion portion of the event. And the event concludes at 1:30. So thank you everyone for being here. We have people from the US, Canada, Poland, Germany, England. So a warm welcome to everyone and a huge thanks to our guest speakers for being with us today. I give the floor now to Jarosław Szczepański.
Hello, thank you for having me here. It is a great pleasure and honor to speak with you. I would like to start with some old Latin question. Who will watch the Watchmen? This old Latin question is more important in today's European Union than ever. And when I say European Union, I mean organization as a whole and each member state separately. After constant complaints on the EU deficit of democracy, we are now facing the problems with democracy on the member state level. This difficult time of trial is also a moment when a fruit of poisonous tree has reaped, the fruit of judicial activism. As late 20th and whole 21st century are constant decline of classical democracy, politicians are searching for alternative ways of securing their goals. The ideal of separation of power allowed the people to control 2 out of 3 branches. The third one, usually perceived as bureaucratic and professional, in the last decades had become more and more influential, mostly by extending its own ability to control the development of the political system. This expand was possible only through judicial activism. You here know it very well, starting with Marbury versus Madison in the early 19th century, continuing straightforward to latest cases on abortion. Academics wrote hundreds of papers about dangerousness of the judicial activism here in the United States and in Canada. You probably feel the threat of the judicial activism of current petrified Supreme Court. On the same time, in Europe, on the supranational level, as well as national level, politicians are fond of judicial activism, are cherishing this practice. In short-sightedness, they think that judicial active courts will push forward their political agenda. Polish internal war over the Constitutional Tribunal, the most judicially active court in the country, began in 2015. The fight is ongoing and currently law and justice is gaining advantage. When so-called crisis with Constitutional Tribunal erupted, I have gave a short interview to Gazeta Prawna that tribunal itself, because of its judicial activism, became Tibet for politicians. Tribunal, which was stripped of its power to provide universal binding interpretation of the Constitution when the Constitution of 1997 was adopted, was judicially active and operated as if so-called small Constitution of 1992 was still binding. I was, of course, instantly under attack by the opposition as a supporter of government. But now, when so-called seized tribunal is judicially active and gives decision in favor of law and justice, my opinion maintains still the same. What is more, the most recent decisions about unconstitutionality of certain interpretation of the provisions of the Lisbon Treaty in its nature are very similar to the decisions that started the war over the tribunal. Namely, it was judicial activism, acting outside of the constitutional provisions, acting in a manner that Polish Supreme Court in many rulings described as not legally binding. And when I say in many rulings, I'm thinking about rulings that were given in 2007, so very far in time from what we are now facing. Because any interpretation is only provided on case-by-case basis, as Supreme Court ruled. All in all, this judicial activism provided us at least two major points to disagreement with European Union. On the European level, judicial activism was in very similar way widely accepted by political class. It is so widely accepted that not only politicians, but also at least some academics are even denying existence of the political activism in Europe. Can you imagine, with your numerous papers on political activism, they do not acknowledging its existence to be able to push forward false statement of non-political character of courts that are able or enabled themselves to interpret constitutions or similar acts on the European level, namely the treaties. It is partially because there wouldn't be nor European Union, neither integration that we know, if not judicial activism. European Union is based on treaties that are written in a way that will allow them to be ratified on national level. No sane government would have agreed in the very beginning of the integration on the provisions that were provided by the active European Court of Justice, now Court of Justice of European Union. Nonetheless, the landmark decisions of European Court of Justice, such as Van Kent and Loos, are foundations of the common market and freedom of movement, for example. The history of judicial activism or judicially active decisions made in 21st century is a history of ever greater union and shrinking of the sovereignty of the states. When I'm teaching EU law, I'm doing it on cases, as treaties gives only general framework, but this framework is only one thing which was provided and agreed by representative governments of the member states. Only treaties are arranged under the democratic principle. Further integration that was possible only because of the judicial activism, even if gave us Europeans numerous possibilities, is arranged outside of the democratic framework. Today's struggle between the EU and Polish government is kind of a proxy war, if you will. It is not fought between democratic representative governments, but by judicially active courts, the European Court of Justice and the Tribunal, Constitutional Tribunal in Poland. If we were only to base on the sole treaties and approach the fight between Poland and the EU with traditional legal positivistic perspective, there is nothing to fight about. But the treaties are mostly irrelevant, as most important principles of the EU are driven from the court decision, and we all agree about that. The most important landmark decisions they made EU as we know today. All that brings us to the first question: who will watch the watchmen? Who has the authority to restrain the judicially active courts of the EU and member states? Thus, European federalists and Polish, or broadly speaking, Eastern European nationalists are aware that their judicially active courts are the main reason for the deficit of democracy? There is no good answer to those questions. What is more, no one is even seriously asking them. Most academics and politicians, which in Europe are closely allied with each other, are preoccupied with pushing forward their agenda and not thinking about bringing back the ideal of democracy, as well as bottom-up approach to European integration, which was the dream of its founding fathers like Adenauer or Schuman. What is fascinating about this alliance between politics and academia is that political scientists are usually the least politically involved in doing politics, maybe because we are used to detach our personal views from analysis and political life. This ultimately pushes us forward to the question of the future of European project, which was severely punched by Brexit and now is drowning in the internal war between East and West, with migration crisis on the borders. My guess, as predictions are probably impossible with such a dynamic situation, are that we are on the verge of negotiations of the new treaty, which will be impossible to be fully adapted by countries like Poland, Hungary, or Slovakia. My guess is that Polexit is impractical for Western companies or corporations, which means that CEOs will probably try to restrain politicians. What is more, Polish government will not act like UK's government with proceeding Brexit through standard procedure. It might be a chain of events that will exclude Poland, but probably not only Poland, from the hardcore of European integration. And the most important event of such a chain might be a new treaty or revision of Lisbon Treaty. In that case, European Union of two speeds might become a reality. Thank you.
Thank you. Now we have Marcin Menkes. Marcin?
Thank you so much. Geneviève, thank you for hosting this event, for having me here. I believe we will all see that this is important both for us domestically back in Poland and of some significance to how Europe defines itself and how we perceive where the European integration should go, or the liberal democracies at large. Now, I was invited today to cover the European response to what happens, but in a way I somehow must refer what I'm about to say to what we heard from the previous speaker, because there were a lot of elements, including the traditional positivist reading of the story, to elements of EU law to which allegedly states joining the EU did not agree. As Geneviève started, Poland joined the EU in 2004, so perhaps something could have been surprising in the early 50s, but not 70 years later. So we'll possibly come back to this by the end of our meeting or discussion part of our seminar. If I could just put it this way, I would put in let's say in brackets what we heard so far. I acknowledge that it's one way of looking at the things. That's, let's say, formalistic understanding of what is rule of law and what the courts are supposed to do. As we heard, the people should take control of, go above the separation of powers, and that's the narrative, let's say, that coincides the view both of the government, constitutional court, and some of the commentators, and I respect that. Now, let's say the European pushback is the other reading of the rule of law, meaning it's not merely about formal understanding of certain rules, including separation of powers, as pointed before, but it's substantive contents. And to this extent, what we heard would be like the domestic perspective of looking at things, and I was supposed to cover today the European response to that. Do you now see you should now see my screen, and That
Yes,
will,
we
all
do.
right. That should help me to run quickly through my part. So generally from the European perspective, that is, I would mostly focus on the European Union, but it also includes the Council of Europe, including its judicial branch, that is the European Court of Human Rights. We would assume, or we would consider the rule of law as the backbone of modern constitutional democracy. And this translates within the framework of European integration into three layers. One is the axiological basis upon which European project was launched. And here I just remind certain obvious facts, like it's a process that allowed to integrate continent with post-World War II Germany. It embraced post-authoritarian Portugal and Greece. It allowed to integrate Central and Eastern European states right after political and economic transformation. So we have the axiological layer that translates into political modes and goals of cooperation. And to this extent, I agree that there is a political component into situation, as Riley pointed seconds ago. But then independently from that, or on top, from my perspective as a lawyer, on top of that, there is the normative layer. And then the substantive contents of the law is, well, what do we want? What kind of norms we want to have is decided through a political discourse. But then the legal norms is one of various normative systems which are independent of the two previous steps. Now, to give a too brief introduction to from European perspective how the crisis unfolded, we had first a political hijack or political capture of the Constitutional Court. That was step one back in 2015 and was a crucial element for the entire crisis, since the Constitutional Court in Poland is a specialized tribunal that is ruling upon the constitutionality of actions taken by all branches of the government. In other words, that turned out to be the central element of the system of checks and balances that prevents any given political majority from adoption of laws, let's say fully arbitrarily or in a discretionary manner, including statutes. Some would claim, like those now in force, that undermine the key values of the Constitution. Having this out of sight, the ruling majority was able to seize control of the National Council of the Judiciary, which in turn is crucial for picking the judges who will sit at the Supreme Court. And once you see Supreme Court, you can trickle down. And this way, the entire dispute concerns constitutional crisis, concerns reform of the judiciary, but it starts at the starting point, the departure point is the Constitutional Court. Now, so what are what's at stake in this situation? Obviously, there are Polish interests, or what will happen to Poland
Marcin?
domestically.
Marcin, sorry, can you move just a little bit your screen? Because we don't see your entire presentation.
When you see just part of the...
We see,
right?
Yes, that's better.
Is that better?
That's better.
Sorry for that.
Or it's because we could see only a chunk of it.
Do you see it now in full screen mode?
That's better, yes.
All right, sorry for that. I thought we had to test it beforehand. So the Polish perspective, obviously what will happen domestically in Poland and what are the consequences for Poland at the international level. The third element, or the overarching element, is the question, what are the consequences for democracy at large and the human rights and all the values upon which European integration is based. Now, my task today was to focus on the European pushback against constitutional reforms. And here the key question is, why do they care? Why do they care? Why the Court of Justice of the European Union, I will refer to it as ECJ, from now on, why is it so active in fighting certain elements of the reform? And the reason for that is that if they allow Poland to carry on with the reforms, it undermines, it undercuts the legal pillars of European integration, including the rule of law, understood as a primacy of the rule of the law, as the grounds and limits for exercise of public authority. It undercuts the very essence of competences, of powers of the Court of Justice as the guardian of the EU treaties. And finally, well, it makes one wonder, why do we have ECJ and European Court of Human Rights, for the matter, in the first place? So what are European institutions doing in response to Polish constitutional crisis? We could divide here the measures available to the EU to two broad categories. One, which I call the tailored measures, and they're largely political. And then we have, let's say, regular judicial or legal toolkit, which can be applied throughout in all areas of the law. Here they have been implemented with respect to rule of law crisis, both in Poland and in Hungary. So for those general, for those political tailored measures, we most importantly have the so-called Article 7 procedure under the Treaty of the European Union. As said in the very beginning, that through European integration process, we managed to create a common space for economic and political cooperation among states from very different political normative background. So to have a level field, that it was necessary to agree upon certain key values, key normative elements of the entire system. And as European Union, following the political transformation in Central Eastern Europe, was preparing to enlarge, to include new members, it was felt that European treaties, funding treaties, needed to be adapted, reviewed, to introduce a mechanism that would allow to secure, to enforce compliance with those key core values, including the rule of law. And so in 1987, EU introduces a new procedure for the safeguard of the rule of law. But at the time, the only available option was to suspend a voting right. Let's say it was a nuclear option, politically largely unthinkable. It also required unanimity among members. So for that reason, pretty soon, if you recall, Jörg Haider's rise to power in Austria turned out it was inefficient. So we added additional layer, an early warning mechanism, a mostly political instrument for monitoring how particular member state is, whether member states and their institutions comply with the EU law. This again proved inefficient, and I'm sharing here just to highlight the available measures and the political preconditions for following this path. This again proved paragraph 2, that is the unanimous decision about declaring a determination of serious and persistent breach of rule of law, is politically unthinkable in situations such like the one we have right now, that is two countries that decided to question key values of the European Union. The first stop is the first element for fifth majority that determine a risk of serious breach of the rule of law is one-stop shop. You have only one opportunity to take this path. If you don't get required majority, the case is closed. For this reason, to facilitate, to develop measures for political dialogue, in 2014, European Commission developed through its communication, adopted yet another political mechanism, vehicle for dialogue that would be activated before this politically tricky or demanding procedure of Article 7. And here we see the clear distinction between the judicial path under the Treaty on the Functioning of the European Union, whereby the state can be sued for violation of certain substantive provisions of the EU law, as opposed to developing Article 7 procedure, whereby we develop a political dialogue, where Commission is actively involved and tries to hammer out a compromise with a particular state and find a common solution to the crisis. So Article 7, bottom line, Article 7 is a set of procedures that foster dialogue between two willing parties, EU and that was the assumption, a member state who still wants to realize EU values, but perhaps disagrees over certain specificities. Now, European Commission, European Parliament felt that it is insufficient, especially because of this high threshold of unanimity. So they were trying to figure out a way out of the Article 7 provision, and the budget fiscal negotiations seem to provide us with such an opportunity. So two new instruments were added to this rule of law toolkit. That is, first of all, European Union introduced in 2020 a mechanism of fiscal conditionality, and you may be familiar with this idea from the International Monetary Fund. That is, the EU will disburse its funds to member states. However, it is believed that in order to have some financial management and effective use of EU funds, then you need a properly functioning set of rule of law institutions. And so if you violate rule of law, you will not be granted access to regular EU funds. This is for now put on hold because of legal challenge launched by Hungary and Poland, but these provisions are already in force since January this year, meaning once the Court of Justice, EU Court of Justice rules upon legality of fiscal conditionality, probably early next year, we can see legal enforcement or application of these fiscal conditionality rules. Additionally, we have new set of instruments, that is the EU Next Generation, a new emergency funding mechanism that will allow EU to issue unprecedented amount of bonds to relaunch, to boost post-COVID, to boost national economies struggling with the COVID crisis. And here again, it is felt that since it will be a common debt, then states, or notably Germany, are very worried about proper spending of these funds. This is element number 3. And then the fourth element, wrongly with the number 3 on my slide, the rule of law mechanism, that is the dialogue launched in 2020. That is an annual screening exercise conducted by the European Commission, who is looking at the compliance, respect for the rule of law at the member state level. And they particularly focus on 4 elements: the functioning of the judiciary, anti-corruption measures, freedom of the press, freedom of speech, and functioning of the institutional checks and balances. So these are the 4 measures tailored for dealing with the rule of law. And then, because I'm running out of time due to unexpected introduction, let me just speed up here. We have a set of ECJ's measures for enforcing EU treaties. And here we could distinguish between two periods of how ECJ interpreted EU law. Early on, or early cases, the EU judges considered rule of law as an element of substantive law in other areas. So for instance, that respect of rule of law was indispensable for labor provisions, or broadly speaking, for the functioning of the EU market. But as the situation unfolded, the European judges gradually acknowledged that rule of law is a part of EU law in itself, and hence it was increasingly acknowledged that yes, it is true that the shape, the structure of the judiciary pertains to domestic competences. Every political system, every lawmaker can design its own judiciary. However, whether the key parameters of the rule of law are respected, including independence, neutrality, separation of powers, and all the contents of the rule of law, not merely its form, is a matter of common concern. That without that, we cannot have mutual trust among the judiciary. So for instance, we cannot have automatic recognition of judgments from one state by the other, or automatic extradition of so-called European arrest warrant, that is automatic extradition between member states. And that finally, if domestic laws violate these key elements of the rule of law, then if you want to stay within EU, its member state, its institutions from such a country, for instance, from Poland, must disregard such controversial provisions. And with that, I'll skip the ECHR part. I'll just say that we have a huge array of European institutions, and they all perceive the Constitutional Court in the same terms, meaning it's not just the form, it's also the substance. And perhaps let me stop here. Thank you.
Thanks so much. So we had like two legal specialists telling us about, how complex actually these issues are. Thank you for clarifying some. You also introduced noise and complexity for people, ordinary people like me. So perhaps also Sławomir Sierakowski can shed light on what actually led to some of these crises in the first place, and how these different systems, legal systems, and the tension between domestic or national interest and EU interest actually are played out domestically and politically, how they relate to the political situation in Poland, especially since the tensions with the EU do start to appear and they accelerate after the coming to power of law and justice. So what is going on politically in Poland that actually brings out these tensions between different modes of different legal systems and different modes of rules of law, if that makes any sense in this kind of more general speak, so to say. So Sławek.
Okay. I must say that I'm also surprised by what Mr. Szczepański told us about the legal context. To make it very short, I think this notion of legal activism means only that very actively the government interprets Constitution and European treaties. I would say that, shortly speaking, we have three important institutions that is like a heart or lungs of the entire legal system in Poland. One is Constitutional Court that has only one aim, that means controlling the laws that are introduced introduced and passed by politicians, whether they are whether they agree with the constitution or not. So who controls the constitutional court controls the constitution. Okay, I mean, if you want to be legal activist, if some government or the party are very active in the legal system. Before, it never happened in Poland that the constitutional court would be under control of any political party. And here, this was the first institution attacked by PiS. The way they did it was like just very blunt. That means that they just selected new judges in places they were already occupied by legal judges, and then they passed and then they changed the general law about the constitutional court. So from I don't know what was the year, 2015 or 16, the judges are all selected by the parliament, and the single party majority in the government is PiS government, or without Andrzej Duda, who is just completely connected to the PiS, and it's a former PiS politician. The second,
sorry, for those who don't know, PiS is the acronym for Law and Justice. Prawo
yes, exactly. When I'm saying peace, I'm not, unfortunately, not saying peace as opposite to war. I'm just using an acronym. The second body is the National Council of the Judiciary. It's important. It has also, in general, put it generally, one aim. It just selects judges. Before, this was mostly judges who selected judges, okay? Usually people with a very good reputation, with huge experience and like moral authorities in Poland, very respected people. Now politicians select judges because the National Council of the Judiciary was also very actively treated by the government and just is now just the internal body of the ruling party, like the Constitutional Tribunal. To put it simply, the president of the Constitutional Court is a person without any reputation, completely unknown before, and it's a friend of Jarosław Kaczyński. That would never happen before 2015. Then there is, of course, the Supreme Court, which is another aim of the ruling party. It's important because it approves the results of elections, of course. It's still not completely captured by what the government did. It created two new chambers in the Supreme Court, only one that can trigger disciplinary cases against judges that are independent, like regular judges in the local courts in Poland, and another chamber that approves elections. And of course, these new chambers were fully selected by politicians. They actually have the double salary, and of course, they immediately started some cases against independent judges, okay? That they cannot rule anymore, that they get 75% on, they are also financially punished, okay? And this is a point, these are the points why you have the conflict between EU and Poland. Also, as my as Marcin Menkes said, what Polish judges rule refers not only to Poles, but to everybody who operates in Poland, including companies as well. So it's not just a Polish thing, or it's an attack on Polish sovereignty when the EU, the Commission, or the Tribunal Court of Justice is in conflict with the institution that operates illegally de facto in Poland. So this is more or less how it looks. Of course, the case is very simple with the judgment of the Constitutional Tribunal on the supremacy of national law over European law. What the Constitutional said, the Polish Constitutional, or as we say, neo-constitutional court, it said that Polish Constitution.
You mean the October 7th ruling?
Yes, exactly. I'm saying what happened just recently.
Yeah.
The Constitutional Court ruled that Polish of course first that EU is widening competences, etc., etc. I just, and don't forget, EU was the accession was passed in democratic referendum in 2003, with the result 77% for and only 22 against. Now in public polls, it reaches 90% the support for EU. So EU enjoys much higher democratic legitimacy than any Polish politicians after 1989, okay? So it's fully legitimate to intervene or be involved in what is happening with the legal system, with the legal order in Poland. And the case was actually very simple, because because nobody questions the supremacy of Polish constitution above the EU law, and no institution in the European questions it. It's obvious, it's not natural. But what EU can involve in are the regular bills, just the law that is passed in the Polish parliament, okay? And actually, it is in the Polish constitution that international law is above the Polish bills. So it's completely senseless of what the Constitutional Court ruled. This conflict actually don't exist. It was only to show to the European Union, or to somehow push back against what EU criticizes, which means disciplinary processes of the judges, and of course of the fact that that the independence of judges is in danger. So, and now let's go to politics, or to just cultural background of it. What populists are fighting with is not exactly democracy. It's rather liberalism, because all these rules like separation of power, independent judiciary, independent media, independent NGOs, these are the rules that comes from tradition of political liberalism in the world. Democracy is just a question of procedures, and it's about elections mostly, okay? So it's important, because to implement democracy, it's just, you can do it in one day. It's like after 1999, when we implemented democratic rules, it was really a question of procedures. But to implement liberalism in the society, it takes generations, okay? And the tradition of liberalism in Poland is very, very weak, because what happened in 19th century when when political liberalism emerged in the Western Europe, in these times, we were like fighting for freedom, we had uprisings, we have wars, etc., etc. So instead of liberalism, what we created is rather the tradition of Polish political messianism. We were like, you know, thinking that we are the victim of entire world, the Christ of nations. We were waiting for somebody that makes miracles, like, and then from this moment, after 1918, when we finally regained our independence, people like Piłsudski, people like Lech Wałęsa in 1980, people like John Paul II, and even now Kaczynski and Tusk are treated by its supporters as kind of a semi-gods, okay? Like a saviors of Poland. This is important to know, because what we have in Poland, it's not the struggle of political adversaries as you have it in Germany or France. We have a war, and it's really treated by both sides as a war. From one side is fighting with another because it thinks that the other side is anti-Polish, that it's an enemy of Polish independence, etc., etc. So the aim is not to win elections, but to eliminate the other side, okay? And things like judiciary system, media, NGOs, etc., are just resources, and they are treated as resources, okay? So this makes actually Eastern Europe different culturally with Western Europe. We can reach the level of welfare, and Polish economy is booming no matter who rules. We are almost equal partner to Germany as friends, which was traditionally the biggest trade partner. But culturally, to reach the level of Western Europe will take generations. This is the reason why Angela Merkel is so patient, restrained, and never asked for any revenge or never even criticized Poland. Germany traditionally delegates all the things to Brussels, never wants to go into open conflict with Poland, because just, there is a kind of a iron culture of iron curtain still existing, but it's about checks and balances. We don't have strong tradition of checks and balances here. So you can have populism in the West, like you had it in the States. But look, if Trump is saying after elections, from now on, we don't want here people from 7 Muslim countries. And the week after or a month after, the local court says it's illegal. Then he backs off, and the life goes on. In Poland, when the constitutional court, the one that was legal before, rules that what PiS did is just illegal, it is against the constitution, the government decides not to print the ruling, and it's enough, and the life goes on, okay? So, and if the society doesn't stay behind the constitution, behind the law, behind the checks and balances, doesn't execute it on the streets, or just, if it doesn't kill the reputation of politicians after doing something in such a conflict with the legal system, then unfortunately it's not easy to survive populism as it is somehow survived. It survived in the States. I mean, come to Poland, I'll show you how it looks like when it's differently. Should I talk more now, or you want us to start the discussion?
I think we can open up for discussion and maybe to responses, but I would like you, what's important also these issues are complicated because also they involve like culture wars, like the way what you're talking, populism, and a democratic backsliding. So this is also why the EU is worried about what's going on in Poland and Hungary, and why they're watching very carefully what's going on in the courts and what's going on.
I can add one point that it would be also important to understand Poland and Polish leaders. Look at the refugee crisis that we had at the border, because also this is the thing that we should talk about, I think, and it's connected to EU, to the EU. Poles were refugees in every generation, okay? Poles were harmed in every generation. But Poles know what it means to live in the forest, to be really, to be hungry, etc., etc. So intuitively, you would expect that Poles would understand the victims, understand these people in the forest, understand refugees, okay? You would expect some kind of solidarity of victims. It works the opposite way, unfortunately. The mechanism is different. Poles are like people who were harmed are of hearts of stones. This is one Polish writer explained it this way. That means that Poles who feel that they were victims. Okay, we have it in public TV all the time. It's about Polish heroes, and we were only victims. We never did anything wrong, etc., etc., etc. So what really happens is a kind of a competition to who is the first victim. Okay, that means that if Poles look at somebody who is really perpetrated at the border, is scared, not solidary. It is scared that somebody will get his place in line. Okay, so the worst government behaves there at the border. People are the more scared are people here, and the more unwilling people are here. And I give you one public poll. 2015, when the refugee crisis were in the Western Europe, and Poland was totally against any relocation, totally. The weekly that I'm working for, Polityczna, did the survey. And the question was, there were two questions. One, if you don't want refugees here in Poland, and the price for it would be resignation from the EU funds, would you still support the unwelcoming of refugees? 58% of this Euro-fanatic society, 58% said, okay, we don't want EU funds, and still not having refugees in Poland. And Poland is the biggest beneficiary of European funds, and always was. But it's not the most surprising answer. The most surprising answer was for the second question. What if the price would be losing membership in the EU? And 99% of people really want to be a part of the EU. It's a question of our independence, not welfare only. 51.8% people said no refugees and no membership. Okay, it shows you that it's that this country have few more dimensions than the West. Let's put it this way.
But I would say, though, regarding the refugee issue, I mean, it's also about race. It's also about religion. It's also, so it's not just the complex of martyrdom and refusing the martyrdom status of others. And there's other things that are going on. And some people weren't supportive of receiving refugees as long as they were Christian from the Middle East. So, so perhaps Jarosław Szczepański and Marcin Menkes want to add something to this before I open to the questions we've received.
I'll be happy to pick up on two things. Partly it resonates with what Sierakowski just said, or this allowed me to reread or hear again what Jarek said earlier from yet another angle. So with regard to what was said in the beginning, with regard to Constitutional Court exercising control over the judiciary, which allegedly means overstepping or trumping separation of powers, I think we could put it both in abstract terms and in concrete specifically. In abstract terms, such a claim, put it this way, ask yourself, what would it mean, for instance, for impeachment procedure or judicial control of the elections, or even criminal acts committed by the executive or the members of the parliament if passing a judgment by the court of law upon actions of other branches means you've trumped separation of powers. And that's in abstract terms. But to give a specific example, what we're dealing here right now. So for instance, one of the substantive elements of the rule of law is that judges are irremovable. Now, the ruling party passed a law by virtue of which they lowered the retirement age for the judges of the Supreme Court. This way, we've slashed 1/3 of the composition of the court and henceforth new hand-picked candidates. And now the claim that the framing suggested by the Constitutional Court is, well, if you allow the court to say that it violated the key premises of irremovability of the judges. That means that the courts control who sits in the court. That means that if you go to a court, perhaps the court finds out that the bench was appointed illegally, so that you lose certainty of law. Well, that is putting the entire matter upside down. So now the problem is not that the ruling party purged the Supreme Court and put in its own candidate. The problem is that someone could call the situation. So that's with respect to constitutional control.
Can I ask you a follow-up on this? So what do you make of the opposite claim that the previous government had stacked the courts with their own judges? Because that's the argument that that Law and Justice is making, that they were basically doing the same thing that Platforma Obywatelska, Civic Platform, had done.
So I think the test case could be the origin of the crisis back in 2015. So the political party that ended the term back then picked judges for the place that for the spots that already vacated, and for the spots that would vacate only upon transition of power, because at the time the former ruling majority knew that they will lose effective control of the government. And at the time, as long as the Constitutional Court was independent, it ruled that the first part of appointments was in accordance of law and struck out the double sitting, those additional candidates. And what was the reaction of the government? As Sławomir mentioned, Prime Minister didn't print the judgment. The Parliament adopted overnight legislation violating procedural rules, and the President has sworn in new judges in a shameful ceremony. That should be like a crowning moment for any justice. You adhere to the Constitutional Court. Instead of that, we had a shameful overnight ceremony without access to public media, without any public participation. So I think that's all about the relationship between these two, the three branches of the government. But I wanted to pick up, perhaps that's my legal twerk, but I wanted to very briefly pick up on one more thing that resonates loudly in my head, that is the notion of traditional formalistic interpretation of law, and how we could wish that the EU goes back to that formalistic reading of EU treaties. To me, that's the reason why the situation is so important, as I believe, for all Western democracies, is that one would expect that after World War II, after great totalitarian systems of the 20th century, we would be finally and ultimately immunized against instrumentalization and formal reading of law. And who better is supposed, who's endowed to understand the consequences of that than Poland, who has been badly scarred by both great totalitarian systems. And what is happening right now in Poland is precisely that is not ruling, it's not a rule of law, but rule by law. It's instrumentalization of law for its own sake, not for pursuit of those axiological values. And I don't want to steal all the time from Jarek, so I'll stop here.
Okay, so if I may, first of all, I would like to totally agree with Sławomir Sierakowski on the division between ideology that is pushed forward and the democratic procedures. Well, democracy can be achieved right away. That's for sure. You can have democratic procedures, yet you can be perceived as non-liberal. And what's going on in Poland is, of course, not fight over the democracy, over the thing that the way that we will try to appoint or elect our political leaders, about the representative government. It is a war between two different ideological camps, and probably Law and Justice is gaining its momentum and has its upper ground, because according to the theory of Lukasz, Kaczynski was able to take a position of agenda setter. He's the one who divided Poland into liberal Poland, or so-called liberal Poland, and so-called solidarity Poland, which is just social, conservative construct pushed forward by Law and Justice. So we have, in fact, two camps, ideological camps that are fighting each other. The wall is almost total. That's also true. I cannot agree more about that. But for our American and Canadian audience, we have to make some remark. Liberalism in Europe and liberalism in the United States are two different things. When you are thinking about liberalism in the United States, you are thinking, in fact, in European terms, about some kind of social liberal or order that will be pushed forward to gain, for example, social benefits. That's for sure. In Europe, we do not have to fight about that. We have that. That's foundation of our system. That's important difference. When we are thinking about liberalism and liberal Poland, as it was named by Kaczynski, when he was starting to frame Tusk in some kind of way, he was referring to, first of all, economic liberalism, and now he tried to combine this approach with cultural liberalism and try to frame his opponents in a way that will suit him. So probably this clash between two ideological camps and how they would like organize a state which will be democratic, but the question is whether it will be liberal democracy or something else, some kind of illiberal democracy, and we have like palette of ideas what can be this illiberal democracy. So that's for sure true. But on the other hand, we are forgetting about the great idea of the axiological foundation of the law. When we are trying to examine the law, we are forgetting that the law, in very similar way that democratic procedure serves as a way to push forward some kind of political agenda, law also can be used in such a manner. And probably both Law and Justice and earlier Civic Platform were trying to push forward their political agenda through the law. So when we are analyzing law and when we are trying to go back to this formalistic traditional way of reading treaties and reading bills, I think that we are not, as a school of law, we are not going to like act in favor of law and justice. On the contrary, we are trying to be to separate ourselves from ideological foundations of provisions. Because when the Second World ended, of course, that was true. We have the Radbruch principle of the law that can be unlawful, and that was the law of Third Reich. That's of course true. But when we are trying to impose some kind of other political ideology into provisions, that's also stepping into boots of politicians, not legislators. And I believe that both Civil Platform and Law and Justice were doing that for many, many years. And just to tackle maybe one question, if I may, from the audience. The first question was about the reason and why Law and Justice. Yep.
I will read because I have my
Right. Okay, if you may.
So actually we do have several questions and I want to pose a couple now and then invite you to respond because we have 20 minutes or so left. So two concerns specifically this issue of the naming of judges. So one question by Thomas O'Donnell from Germany is specifically about this issue of decommunization and lustration. So, what do you make of the argument that lustration did not go as far as it could in Poland as it did in other former Soviet bloc countries, and therefore that what Law and Justice is doing is pursuing that process? So that's one question. And another one related to this is one question posed by Richard Valavender from here, Michigan, who's asking us as a kind of thought experiment, what do you make of the system in the US where the president basically nominates judges to the Supreme Court and where therefore whoever is nominated to the court is, or a name to the court for life is a political nomination. So that these are two questions regarding this. And then we have other ones that are more sociological. In your response, if you would want to consider also other types of cleavages between in Poland that might impact the support or not of Poland's presence in the EU. So for example, in Brexit, there were important cleavages between urban centers and cosmopolitan centers and rural areas, or between certain regions of the UK and others. So we have here Agnieszka Skorer, who's asking you to consider other types of cleavages than just political ones. And that goes back probably also to the refugee issues also. What kind of divides exist in Poland that make some people more inclined to accept refugees and others not to? So I will ask you, maybe the three of you, to go and to respond to this. Is that, Jarosław, is that okay with the question you were trying
that's
to?
Right. I was trying to tackle that very same question. So,
Perfect.
well, if I may start, I would like to wrap up and be just quick in responding. So first of all, the illustration. I think that for many Poles, the time healed the wounds, or at least we are aware that many decades after the transition, it is a little bit too late for illustration. So what is Law and Justice going on, and what they are trying to do is rather to seize the third branch of power to secure that their reforms will be implemented. That's like basic experience that they had when they ruled for the first time in early 2000. Their reforms were stopped by the Constitutional Tribunal, and they learned from their mistake or very poor position that they were in early 2000, that they have to have their Constitutional Tribunal behind them to secure that this, well, let's say, stopping power of the Constitutional Tribunal won't be launched against them, so they will be able to push forward their reforms. And they were able to do that perfectly. But as Marcin Menkes mentioned, there were some peculiar decisions made by both parties in 2015. Some may be more evil than other, but still both parties were involved in that crisis, or making that crisis up, let's say. And without that crisis, which of course Civic Platform knew, Law and Justice would have secured their position in Constitutional Tribunal. They would seize Constitutional Tribunal, quote unquote, seized. So yes, that basically is the answer. They are trying to make sure that no judicial branch of power will intervene in pushing forward new bills. And maybe, if I may, just quickly tackle the issue of the United States judicial system and how those justices in Supreme Court are appointed. Well, that's true that the president has the supreme power when it comes to appointing the justices, but it has to be also approved by the Congress. And it's the very same thing in Poland. We also have to have some kind of interference in the procedure of the parliament. So it is not, it's just a common practice when we are thinking about check and balances, even when we are trying to apply the separation of power, we also have to apply some kind of checks and balances. And the idea that other branches will also participate in nominating such a powerful, in fact, political figures, it's kind of obvious that both president and Congress will take part in the process. And same in Poland, we have to arrange a process which will include as many institutions, political institutions, as we could to check some misconduct. Yep, that's my answer to that.
Thank you. Sławek, Sierakowski, do you want to answer or?
I will concentrate on one question. It's about these cleavages behind like what's visible or like discussed in the international press. But also I would like to say a word about the like similarity concerning the question of how judges in American court Supreme Court are selected. First of all, being selected for life immediately gives you independence. So there are, even in peace, who is like very, I would say, coherent institution, and in a sense that like they really cooperate with only with the people who are their people. Okay, they don't risk that somebody from outside. It's very important. So like if Fidesz in Hungary is a mafia and it's about business and so on, Peace Party led by Jarosław Kaczyński is a cloister. Kaczyński doesn't have a bank account, driving license. He's like a king ghost from Polish 19th century, a little bit crazy romantic literature. But even in this constellation of institutions, some judges recently in the Constitutional Court gave votum separatum to the ruling, but they were selected by peace, but only because to be selected to the Constitutional Court, like for 9 years, if I'm correct, with like very, very high salary, etc., etc. It makes you safe that now you from now on you can like go with your like with what you think is reasonable, not what Kaczyński thinks. Okay, so this is a good thing actually, and the fact that you cannot in the States select all judges in the same time or even in one term, and so it's like, you know, it's unpredictable, it's not controlled from this point of view by any one party. It makes huge difference with what we got in the Constitutional Court or the National Council of Judiciary, where just politicians passed a new law, selected everybody, and it's done. It's a different situation than in the States. The cleavages. What's important is the main cleavage, as I said, is between liberals and illiberals. And it's not my interpretation, it's what Orban and Kaczyński said openly. We are creating the new international of illiberals. We have army, we count on 100 million people in the EU. Of course, Orban, unlike Kaczyński, has international ambitions. Kaczyński is isolationist. We just don't intervene, don't care about us. We're gonna deal with Poland with our own hands and so on. Kaczyński doesn't travel, doesn't meet any foreign politicians except for Orban. So it's like, it's totally two different perspectives. What's the difference between liberals and illiberals? They have different definition of democracy. For Kaczyński and illiberals, democracy is about who won elections. You won elections, that it gives you hegemony. Okay, you decide about the constitution, about the law, about whatever, everything. They always say, who won elections? We won elections. So we are fully legitimate to do what we think our reform of judiciary is good for us. Okay, so what they disrespect is a question of limiting limiting politicians, like what's independent from them. They don't accept independent institutions because they say we won elections. Okay, so why an independent institution is questioning what we can do? Okay, so it's a like sovereign definition of democracy rather than liberal definition of democracy that usually consists of two things: who won election is very important, can lead the country, but minority has its own rights, and the party has to go with the legal system, by the rules, all right? But one thing is important to understand Polish situation and the possible scenarios. Actually, PiS has two electorates, not one. And typical impression, typical stereotype about PiS supporters is that it's just one fanatical group, okay? No, the fanatical group is is big, and it's all PiS is the owner. They always have, no matter what, they won 8 elections, they lost 8 elections in a row, and Kaczyński was never questioned by the party. 25 to 30% of people, it's really an army, okay? They behave like members, they look at the contact with politicians, they have a lot of clubs, they have like pretty strong civil society around the party, okay? But what made a difference in 2015 and what secures power for them is so-called cynical electorate, okay? So it comes from the main cleavage. The main cleavage in Poland is actually very similar to the main cleavage in the States. Metro Poland versus non-metro Poland. Like you have metro America and non-metro America. And the division goes, correlation is like almost 100%. PiS lost in local elections. You take big and middle cities in Poland. We have 107 of them. Opposition won in 102 in last local elections, okay? So PiS controls Poland because it wins in the province, villages and small towns. This is it. It's actually, in Poland, it's enough. But this so-called cynical voter that gives them this additional 5–10% are the people who are actually more similar to the opposition, to like civic platform. And they actually are openly critical to what PiS is doing. They hate public TV because it's like Soviet propaganda. They see what's going on. So always, whenever you ask people about, usually except for refugees, majority of Poles is against capturing constitutional court, etc., etc. Although the people who are in strong disagreement with PiS, some of them still are voting for PiS. Why? Social transfers. PiS is the first party that launched really big social transfers, whereas the previous governments were always saying, "Listen, budget is everything. We can't have we just have to wait." Okay, so it was pretty similar to like the communist utopia. It was more or less like pretty neoliberal utopia. 1999, this was the year of Polish breakthrough, but also publication of Fukuyama book, The End of History. This was the common impression in Poland. There is no alternative for market economy. PiS questioned this fact and survived in a sense that, you know, the poverty in the villages, it's much, much smaller, much limited. This is the way how they got additional legitimacy to rule in Poland, and unfortunately, it shows the mistakes of the previous governments. So this is the main cleavage, more or less.
Thank you for this. Marcin, do you want to have the last few words? We have like 3 minutes, 4 minutes.
And then, sure, thank you. Then let me very briefly pick up on the legal elements of the questions. Thank you for all the questions. With regard to what Thomas O'Donnell pointed out, the reasoning, rationale behind the amendment or the reform of the judiciary, it is true that one of the reasons it was supposedly to serve was to purge the judiciary of the descendants of communist judges. The other claim was that it would increase effectiveness of the judiciary. With regard to the first one and the getting rid of former communist judges, it turns out that among the persons that have been forced into constitutional court, we have, for instance, a very active former communist prosecutor, whereas the ruling party got rid of several judges who used to be stellar lawyers for the opposition democratic movement. So to this extent, that falsifies the entire claim for trying to cleanse, if you will, judicial environment. As for effectiveness, just focusing on the Constitutional Court, once they seized the Constitutional Court, it was the year in which, ever since, we have a record years with regard to lack of demand for its services. So once the party acquired control of all the institutions, suddenly it turns out that none of their own institutions sees any need for Constitutional Court. And finally, from the European point of view, no one prohibits the illustration law as such, or the concept of getting rid of the judges. The question is how you implement such a reform, not whether you do it or not. And if I have 1 minute, Geneviève, I wanted to pick up on Richard Valavander's point with regard to what would happen, possibly happen, if the Court of Justice was to pass a judgment upon the U.S. system. Given what it said, how it assessed the Polish reforms of the judiciary, it says that there are two components: objective and let's say subjective elements that contribute towards independence of the judiciary. So the political components, as both four speakers mentioned, it is in the US. It is in Poland. It is in a number of other EU member states, including Germany, which is a favorite example of the Polish ruling party. The question is how we combine these elements. And I just made a very quick list of how it works in practice. We have the former members of the parliament who passed those questionable laws that now sit on the Constitutional Court. We have the former prime minister and the head of the ruling party who declared openly his unexpected friendship with the newly appointed president of the Constitutional Court. We have the former member of the Secret Service that's sitting on the Constitutional Court. We had a scandal with a so-called group of haters of lawyers in the Ministry of Judges who were spreading or sending some hateful speech or messages against judges who disagreed with the reforms. We have recent judgment of the European Court of Human Rights, who declared it's unthinkable that the Minister of Justice can discretionally move the judges, swap them among different regions, among different levels, and depending on, that's what happens, depending on how you, that's last sentence literally, depending on what's your attitude towards reform, your career either skyrockets, and from regional court you can end up in Supreme Court in a matter of several months, or you were downgraded from the Supreme Court and end up in rural court, I think against rural communities, but far away. We're going
to be cut.
Right? Thank you.
So I will thank you. I want to thank the three of you, Marcin, Menkes, Sławomir, Sierakowski, and Jarosław Szczepański, for being with us today. We didn't talk about what the current refugee crisis means for the relationship between Poland and the EU. We'll have to have another event for that. But in 2 weeks on Wednesday, CRIS is hosting a lecture on neo-nationalism and de-democratization in Hungary. So I invite you to join that event. And then we come back on December 8th for a book series talk, In the Midst of Civilized Europe, the Pogroms of 1918 to 1921, the onset of the Holocaust, by Jeff Weidlinger, here, professor at the University of Michigan. So thank you, everyone. I'm sorry that we could not answer the last two questions, but I tried to include as many as we could. And please join us again. And thank you again for being with us today and sharing your expertise.
Thank you very much.
Thank you. Thank you.
Thank you. Bye-bye.
Thank you for having us.